Hello, welcome to EPG Pathshala, the course Legal Literacy. I am Maruk Edenwala, one of your course teachers. The subject, Child and the Law. This is the last module with regards to this subject. In this module, we are going to look at the provisions of the Protection of Children from Sexual Offences Act 2012, which in short is called the POCSO Act. The POCSO Act specifically deals with sexual offences committed against children. It was a demand of child rights activists that children against whom sexual offences were committed were not being adequately dealt with under the general law. The National Crime Records Bureau, Government of Home Affairs, each year comes out with statistics regarding crimes in India. The Crime in India 2014 was the first year when statistics were collected regarding POCSO cases. It showed that there were 8,904 cases registered under the Protection of Children from Sexual Offences Act in 2014. Crime in India 2015 shows that there were 14,913 cases registered under the POCSO Act in 2015. What I would like to say is that the number of children against whom sexual offences are being committed is very large, and their age is also reducing. The Protection of Children from Sexual Offences Act 2012. What was the need to enact this separate law to cover children against whom sexual offences were committed? One, the Indian Penal Code that deals with sexual offences was not finely calibrated. Hence, it was most inadequate regarding children. More so because the definition of rape under IPC, the perpetrator is a male and the victim or survivor is a female. But we know that boy children are also victims of child sexual abuse. They were covered under Section 377 of Indian Penal Code, which penalize consensual sexual activity also. Hence, there is a demand from the human rights field to repeal Section 377. Hence, the need for a separate law for children against whom sexual offences were committed. Secondly, the procedure under the Criminal Procedure Code was not child-friendly. A child would require to confront the accused and be rigorously cross-examined by his lawyer. Most importantly, a child requires support while journeying through the criminal justice system. Any support provided to the child by a social worker will be looked upon suspiciously. Hence, there was a demand that the law within itself should recognize that children require support. The preamble to the POCSO Act. An act to protect children from offences of sexual assault, sexual harassment and pornography, and provide for establishment of special courts for trial of such offences and for matters connected therewith or incidental thereto. Definition. Who is a child under this act? A child means any person below the age of 18 years. What are the main features of the act? This act is gender neutral. That means the offender could be male or female and the child could too be male or female. Statutory age. The age of consent to sexual activity has been increased from 16 years to 18 years. This is being greatly debated, because many believe that this increase in age has resulted in criminalizing a consensual activity. A consensual activity which children at this age are prone to due to experimentation. The broad calibration of offences, these are not the categories named under the Act, but it's a broad calibration. Certain sexual offences are penetrative, others are the touch sexual offences, third, non-touch, and it also deals with children who have been used for pornographic purposes. No discretion. Earlier, under the IPC, the courts had discretion to award punishment less than that which is stipulated under the Act on certain special grounds. This discretion has now been removed from the court. So now the court has to award the minimum sentence which is provided under the Act. Burden of proof. In criminal law, the burden of proof is upon the prosecution. But for certain sections, certain serious sexual offences, under the POCSO Act, the burden of proof has been shifted. It has been shifted from the prosecution to the accused. Now, the accused has to prove that he did not commit penetrative sexual assault, aggravated penetrative sexual assault, or aggravated sexual assault. The presumption is that the accused has committed it. He has to tender evidence to show that he did not. Now we are looking at the first category of sexual offences, that is penetrative sexual assault. It is covered under Section 3 of the Act. 4 types of penetrative sexual offences are covered under this section. Please look at the first category. Penetration of penis into vagina, mouth, urethra, or anus of child, or making the child do so with such other person or any other person. What this provision means that the penetration may be done upon the child or the child may be made to penetrate. Still, the offender is the person who is making the child do this act or involving or engaging the child in such act. What do we mean by with or any other person? That means that if a person is not engaged in penetrative sexual assault but forces 2 other persons to commit penetrative sexual assault, the person who has forced them to do so is the perpetrator, even though he has not penetrated. So the category 1 deals with penile penetration. The next category deals with object or penetration by any other part of the body. The third category deals with manipulating a child's body to make the child penetrate himself or herself, or making the child manipulate the offender's part of body to penetrate the body of the offender himself. The fourth category deals with oral sex. Under this section, the punishment is minimum 7 years and maximum to life imprisonment. What is the aggravated form of an offense? An aggravated form is when the caretaker or a person in authority commits a sexual offense upon the child, or such person takes advantage of the vulnerability of the child, or it is committed in certain situations or circumstances. If a child is below 12 years of age, the offense becomes aggravated. For example, a police personnel committing penetrative sexual assault upon a child would be looked at more severely, because since the time the person is a child, the parents tell them that if they are in difficulty, they should approach the police, and the police has taken advantage of this position of authority. Same is the case with regards to armed forces or security forces and a public servant. You will also notice that institutions, whether residential institutions, medical institutions, if management or staff of such institution commits penetrative sexual assault on a child residing in that institution or getting services from that institution, will also be treated as an aggravated form of such offense. Gang penetrative sexual assault is also aggravated. Please see item J. If the penetrative sexual assault physically incapacitates the child or causes mental illness to the child, that will also fall under an aggravated form of offense. See point K. Mentally or physically disabled child. If penetrative sexual assault is committed upon such child, it amounts to taking undue advantage of the vulnerability of such child. Please see point N. It talks about a relative who is in a position of trust, who commits penetrative sexual assault on the child. The relationship may be through blood, it may be through adoption, it may be through foster care. Point S. It is noticed that during communal or sectarian violence, power is shown by the dominant group by sexually violating women and children. Hence, this also has been treated as an aggravated form. Clause T. If a person has been earlier convicted for having committed a sexual offense and repeats a sexual offense, it is treated as a more severe form. U. Stripping a child and parading them naked in public is often seen in cases of caste violence. So from A to U, all these instances are treated as aggravated, and here the minimum punishment is 10, but it may extend to life imprisonment. Sexual assault. Section 7 deals with touch offenses, but there is no penetration. With sexual intent to touch the vagina, penis, anus or breast of child, or making child do so with such person or any other person, or any other act with sexual intent involving physical contact without penetration. So, the foundation of this provision is sexual intent. How are we going to find out whether an intent is sexual or not? Obviously, touching the vagina, penis or anus or breast of a child, the intention can be nothing but sexual. But when we are talking about any other physical contact, whether it is a sexual intent or not has to be weighed from case to case. Often a child may inform that the touch was most uncomfortable. In sexual assault, the punishment is minimum 3 years and it may extend to 5 years. There is also aggravated sexual assault. The same categories which we saw in section 6 are also covered under section 9. That is, all those from A to U. In aggravated sexual assault, the minimum punishment is 5 years and it may extend to 7 years. Sexual harassment, section 11. There are different categories which amount to having committed the offense of sexual harassment. For all these categories, the intent must be sexual. 1. Utter any word or make any sound or gesture or exhibit any object or part of body. Exhibitionism is covered under clause 1. 2. Makes a child exhibit any object or part of body. 3. Shows any object or media to child for pornographic purpose. 4. Constantly or repeatedly follows, watches, or contacts a child by any means. Constantly or repeatedly following a child is stalking. Constantly or repeatedly watching a child is voyeurism. 5. Threatens to use a real or fabricated depiction of any part of child's body or child involved in sexual act. Entices a child for pornographic purposes. Here the punishment is imprisonment, which may extend up to 3 years. You will notice that in all these sections, it is punishment plus fine. Using a child for pornographic purpose is covered under sections 13 and 15. Using a child in any form or media, whether electronic or printed, for purpose of sexual gratification, which includes 1. Representation of child's sexual organs. 2. Child engaged in real or simulated sexual act. C. Child's indecent or obscene representation. Here the punishment will extend up to 5 years. Recognizing that pornography is an organized crime, the subsequent offense has been treated more severely. Here the punishment may extend up to 5 years. The punishment is more severe if the person also commits a sexual offense against the child while the child is being used for pornographic purpose. Under this act, storing for commercial purposes any pornographic material involving a child is also an offense. Under the IT Act, it is not mere storing, it's also the disseminating. But here, mere storing is also an offense. Here the punishment is up to 3 years or fine or both. Section 42. If an offense is an offense under the POCSO Act as also an offense under any other law, the punishment that can be awarded to the offender is the one which is harsher. An attempt and abetment to commit a sexual offense under the POCSO Act is also treated as an offense. Attempt to commit an offense is punishable with half the maximum term of imprisonment for such offense. Abetment, the punishment for abetment is the same as the perpetrator would get. Bail. The POCSO Act does not have any specific provision for bail, so we will have to go to the Criminal Procedure Code. Schedule 1, Part 2 of the Criminal Procedure Code states that an offense punishable with imprisonment for 3 years and more, including life and death, is bailable. Bail. There is no provision under the POCSO Act with regards to bail. Hence, we have to go to the Criminal Procedure Code. Schedule 1, Part 2 of the Criminal Procedure Code states that an offense which is punishable with imprisonment for 3 years or more, which may include death penalty, is a non-bailable offense. An offense punishable with less than 3 years is a bailable offense. You will see that all the sexual offenses under the POCSO Act, the punishment is 3 years or more, hence these offenses are non-bailable. Another very important part of the POCSO Act is the procedure relating to children. To ensure that a child feels comfortable and is being able to communicate with the police at the investigation stage and is able to communicate with the court at the trial stage. The police, while recording the statement of the child, should not call the child to the police station. The police should go to the child's residence or the place of a child's choice. The police should not be in uniform, and preferably a woman police officer should record the statement of the child. Of course, if it is a male child, a male police officer may record this statement depending with whom the child feels more comfortable. The police officer recording the statement should be above the rank of a police sub-inspector. The rationale for this is the higher the rank, the more responsible the personnel should be. To enable all efforts should be made to enable a child to communicate. Hence, the child should be provided with the assistance of a translator, an interpreter, or a special educator if a child is suffering from any mental disability. The child's statement should be recorded by the police in the presence of a person in whom the child has confidence and trust. It would be preferable if the child's statement was recorded by audio-visual electronic means. Special court. Under this act, a special court is to be created. A special court should have a child-friendly environment. Means the child should be able to communicate freely and without fear and inform the special court about what has occurred. A trial should be in camera. By that, we mean that the general public should not be allowed to be present in court while the child is disposing, though a family member, guardian, relative, or any other person in whom the child has trust may remain present before the special court. We know that matters in courts are repeatedly adjourned. But the POCSO Act states that the child should not be called repeatedly to testify. Hence, if the child is present in court, her or his evidence should be recorded. Please see point 4, it's extremely important. A special public prosecutor is appointed for the special court. The fear is that the accused lawyer generally tries to confuse the child victim while the child is in the witness box. Also, he talks in a very aggressive fashion which scares the child. To curtail this practice, it has been provided that the defense lawyer will put the question to the judge and the judge in turn will put the question to the child, so that the child is able to understand the question and is not fearful due to the aggressive fashion of questioning by the defense lawyer. There should be no aggressive questioning or character assassination of the child. The court should be in complete control of the proceedings and should stop the badgering of a child witness. In Bombay, the Sessions Court sits from 11 to 2 and 2:30 to 5. A child would get very tired if they have to testify for such a long period. Hence, this act states that a child should be given rests if necessary. This matter under POCSO should be completed as soon as possible. Hence, it is stated that the evidence of the child victim should be recorded within 30 days of the charge sheet being filed, and as far as possible, the trial should be completed within 1 year of the charge sheet being filed by the special court. The alleged offender has committed the most horrific acts upon the child. If the child is faced by the accused, the child is frightened and may not be able to communicate. Hence, this act under section 24, subsection 3 states that the police at the time of investigation should ensure that the child is not confronted with the accused. Section 36 provides for the special court to ensure that the child is not exposed to the accused in any manner. Though, of course, recognizing that the accused also have rights, the accused should be able to hear what the child is saying and should also be able to communicate with his lawyer. Hence, an arrangement and infrastructure should be provided in the court whereby the child is not able to see the accused. Maybe a curtain should be put across the court, or the child should be with video conferencing in touch with the court, or a one-way mirror may be used. But the essence is that the child should not be able to see the accused, because then the child will not be able to communicate with the special court or with the police. Special court, in every district, a sessions court has to be appointed or designated as a special court. A special public prosecutor having at least 7 years experience should be appointed as a special public. It is also necessary to ensure that the identity of the child is not disclosed at any time during investigation or trial. If one feels that disclosure is important, keeping in mind the best interests of the child, permission from the special court should be taken. This is a new concept which has been introduced under the POCSO Act. Mandatory reporting. What mandatory reporting states is that any person who knows that an offence under the POCSO Act has been committed, he must immediately inform the police. If such person does not disclose the commission of such offence to the police, that person himself is guilty of having committed an offence, and he may be imprisoned up to 6 months or made to pay a fine, or both. There is also an obligation upon the police under section 21 subsection 1. Any police personnel who fails to register an FIR when such information is disclosed to them is also punishable under section 21. Under section 20, a particular obligation has also been placed upon hotel, lodges, hospitals, clubs, studios, photographic facilities. If they come across any material or object which indicates that a child may have been sexually exploited, must report the same to the police. If they fail to do so, they are also punishable. This provision of mandatory reporting is looked upon more severely when the management of an institution where a child is kept fails to disclose commission of a sexual offence committed upon a child staying therein by a person who is subordinate or under his control. In such case, the punishment is extended to 1 year. This new provision of mandatory reporting is also being debated as to what are its pros and cons and its impact upon the child. Will all children be forced into the criminal justice system, even those who do not want to? But others argue that bringing them into the system will enable them. Though others argue that bringing child victims into the systems will enable them to access other services such as medical treatment. It is an offence if the identity of a child is disclosed by the media. Another very important provision under this Act is compensation. The special court has the powers to direct the state government to provide compensation to a child against whom a sexual offence has been committed. It doesn't matter whether the accused has been traced or not. It doesn't matter whether the accused has been acquitted or convicted. The injury and damage has been caused to this child, because of which rehabilitation is necessary. Under Rule 7 of the Protection of Children from Sexual Offences Rule 2012 deals with compensation. Interim compensation also is payable depending upon the needs of the child for rehabilitation. Please see bullet point 2. Compensation is payable when the accused is convicted or acquitted, discharged, not traced, not identified, and in the opinion of the special court, the child has suffered loss or injury as a result of that offence. So, Payment of compensation has nothing to do with the accused. It is for the purpose of rehabilitating the child, and the state government is required to make such compensation. As we earlier mentioned, a child requires support while journeying through the criminal justice system. Hence, Section 39 of the Act provides for professional and experts having knowledge with regards to the psychology, social work, physical or mental health and child development should be there to support the child at the pre-trial and trial stage. That is, before the police and before the special court. A child is also entitled to the services of a lawyer, and the National Commission for Protection of Child Rights and the State Commission for Protection of Child Rights are to implement there are several linkages between the Juvenile Justice Act and the Protection of Children from Sexual Offences Act. If you look at the rules, these linkages are in detail laid out. The most important linkages is that the Child Welfare Committee may appoint a support person to help the child through the pre-trial and trial stage. Another important provision is that a child who has been sexually offended by a person residing in the same household with him, or if a child resides in a residential institution by staff or management of that institution, the child should be produced before the Child Welfare Committee so that the Child Welfare Committee can take appropriate steps with regard to such child's rehabilitation. In all other matters, the Child Welfare Committee should be informed that a sexual offence has been committed against the child. Social workers have lots of space under the Protection of Children from Sexual Offences Act. They can also be appointed as support person by the Child Welfare Committee or by the family of the child. A social worker plays an important role to enable the child to handle the trauma better. For further details, you may look at my note, the text under the POCSO Act. Thank you.